Okay, guys, so what we're going to do today is we're going to start our 63-hour sales associate cram course. What I did was, after teaching the course, I put together a cram course document. It's about 150 some pages, and it basically takes each unit of the exam, breaks it down to how many questions you'll see, and it solidifies the information for a review process. So we're going to take this and we're going to start with unit 1, work our way through into a future unit as far as we can today. And then we will have a second part where we do from the unit we stop to the end. Okay, so let's start with unit 1. If you guys have any questions in the meantime as we're going through it, just ask the questions. And you know, you have a copy of this. I gave you a copy of this. So this is something you want to reference. If you want, highlight things or make notes, but these are things you need to know. Okay. So unit 1 is the real estate business. What is it? How's it operate? What's it constructed of? Okay, 1% of your exam is on this. So you'll have 1 question out of 100 on this unit. Okay, so we narrowed it down. So the first thing you want to do is you need to be able to describe the various activities of a real estate brokerage. And it consists of 3 things: knowledge of property transfer, knowledge of market conditions, and knowledge of how to market real estate and businesses. That's the 3 activities. And there's 5 different sales specialties within those activities. Okay, you have residential business, commercial business, industrial business, agriculture business, and businesses. Okay, so residential obviously is residential living. Commercial is obviously retail and restaurants and business buildings. Industrial is more of your warehousing and your manufacturing. Agriculture is your farming, or your livestock and horse farms and things like that. And businesses are either a business with the real estate or a business with a long-term lease when somebody sells a business. Okay. Next, you need to identify the role of a property manager and the situations that require a CAM license. Okay. So property management is professional services to maintain and manage property on behalf of the owners. The scope of their work is detailed in their management agreement. It involves leasing, managing, marketing, and maintenance of property. Now, a CAM license is required for a salaried manager of an association with more than 10 units or an annual budget in excess of $100,000. So if either of those happen, you need a CAM license. If not, you don't. Okay. And then describe the activities that require appraiser services, the U.S. PAP forms, and state regulation of appraisers, and distinguish among a CMA, BPO, and an appraisal. Okay, so what are appraisals done for? And the following: it's mortgage loans, property tax assessment, insurance adjusting, investment. Okay, and all appraisals, if it's called an appraisal, it must conform to the U.S. PAP regulation and form. It must be on a form. Okay, appraisal is to originate a federally related mortgage loan. Also, appraisal that does not involve a federally related transaction does not require a licensed appraiser. A licensed broker can do that. Okay. Now you have also competitive. Now, what's a competitive market analysis? That's the CMA. Okay, it's a marketing tool prepared for a buyer or seller. Okay, they analyze recent sales of similar properties currently offered for sale, and recently expired listings. They may not be referred to or be presented as appraisals. You cannot call them appraisals. They do not have to comply with the U.S. PAP regulations or on a form. A fee may be charged for a CMA. Sales associates compensation must be to the employing broker. So if a fee is charged, it has to be paid to the brokerage, not the agent, right? Because all funds come through the broker. And then you have a broker's price opinion. Okay, this is a broker's written opinion of the value of real property, often requested by a lender for distressed property sales or by relocation companies. It's also done when there's hurricane storms and things come through, and the insurance companies want to check on the properties. Also, when you want to remove PMI insurance from a mortgage, they do them as well. Okay, again, this may not be referred to as or represented as an appraisal. BPOs do not go on the USPAP form and do not comply with the USPAP standards. Okay, sales associates may complete a BPO for compensation. However, the sales associate must be supervised by a broker and signed off by the broker. Compensation must be paid to the broker, who then compensates the agents or associates who did the work. Okay. Now, understanding the mortgage process and the role of mortgage loan originators. Okay, a mortgage originator is an institution or an individual that works with a borrower to complete a mortgage transaction. It can either be a mortgage broker or a mortgage banker. Okay, that's what you need to know that for this section. So the other thing you need to know is how to explain the 3 phases of development and construction. Okay, you have 3 steps. You have land acquisition. That's when you gather the land, buy the land. Subdividing and development. Subdividing is converting the land into smaller parcels, and development is improving the land so it can be used. And then number 3, you have recording the plat map. That's what needs to be done in 3 phases of development and construction. Okay, what are the 3 categories of residential construction? You have speculative, custom, and tract homes. Speculative is when the builder builds the home. There's no contract, no pre-sale. They just build them however they want, and then people buy them. Custom is under contract for one buyer. One person has a piece of land. They design a home they want to have built, and the builder builds that home. It's a custom home. And tract homes. Buyers see a model home, so they have 3 or 4 different models, and they choose a floor plan to be built on an available lot. So they have a lot available over there. They like home number 3. They pick out the colors, whatever they want to do, and they put it on lot number 3. That's tract homes. Okay. Now let's take a look at Unit 2. Okay. Unit 2 is about real estate license law and qualifications for licensure. There are 6% of the questions on your state exam from this unit. So you're going to have 6 questions out of 100. Okay. So the first area you want to look at and what you want to be able to determine is to distinguish among the federal and state laws and administrative rules important to real estate. So you have to remember, Chapter 20 is the umbrella, it's the executive branch of Florida government. Chapter 475 Florida statute is the Real Estate Professional Practice Act. And that's broken down into 4 parts. Part 1 pertains to real estate brokerages. That also pertains to sales agents, schools, okay, and brokers. Part 2 pertains to real estate appraisers. Part 3 pertains to Commercial Real Estate Sales Commission Lien Act. And Part 4 is Commercial Real Estate Leasing Commission Lien Act. Okay, so that's your 475 Florida statutes. Now, you have Chapter 455 Florida statutes. And this is creating the business and professional regulation. Okay, the DBPR. Okay, it's the legal practice and procedure for the DBPR. Okay, non-US, and one thing you want to remember for this section is non-US citizens may hold a professional license. They have to have a green card, and they have to have a social security number to be able to get a license. However, they do not have to be citizens. You may see something on that. Okay. Then you have Chapter 120 Florida statute. Okay. And that's going to be your Administrative Procedures Act. Okay. That outlines the disciplinary process for the real estate, for the whole situation. That says what their process is when disciplinary is taken care of. Okay. And then Chapter 61J2 is actually the rules of the Florida Real Estate Commission. It has to do with all the ethics, and it's the rules of what you must follow. Okay, that's what you need to know for that information. Now the next thing is to distinguish among the 3 license categories. Okay, so you have a sales associate license, you have a broker's license, and you have a broker associate license. So a sales associate performs real estate services for compensation under the direction of a broker or an owner developer. If they're working for an owner developer, An owner developer is an unlicensed entity that sells, exchanges, or leases its own property, such as a real estate development company. So because they own their own property, they can be selling it. They don't need a license, right? Sales staff must hold a real estate license if they're paid a commission or compensated on a transactional basis. If they're getting a salary and no bonuses and no commissions, they do not need to be licensed, right? Then you have a broker. A broker requires additional education and passing the broker license exam. Okay. And then you have a broker associate. They hold a broker's license, but is registered and works under the direction of another broker. So basically, they're a sales associate who got their broker license. However, they're still working as a sales associate, but now they're called a broker associate. Their capabilities and legalities are still the same as a broker associate as they are a sales associate. Okay. Now let's describe license application requirements. Okay, you must complete a real estate application. You must have your fingerprints done. You must have your background checked with the FBI and the FDLE. Okay. Okay, now also you got to be 18 years of age, you know, and of good ethics and morals, right? Now let's describe non-resident application requirements and explain mutual recognition agreements. Okay. So this recognizes the education and experience from another state or nation that has a mutual recognition agreement with Florida. This applies to non-residents only. Okay. If they're mutual recognition, their certification of license history and mutual recognition state. There's a few states. I think it's 17 or 7 or 17. I got to look at it. If they have mutual recognition, what they'll do is they'll get a license history of all their history in the state, and then they send it in with their application. And if they qualify, all they must do is pass a Florida-specific 40-question real estate law exam, and they must get a 75, which is 30 right. So, for example, if they're in another state that has mutual recognition, they're able to submit that information, take a 40-question test, pass it, and get their license. Now, if they're not in a mutual recognition state, and let's say they've been in real estate for 2 years of the last 60 months, worked for 24 of the last 60 months, and they're a broker, they're able to come to Florida, use that history, and go right to being a broker. They don't have to do a 63-hour and be a sales agent for 2 years, then be a broker. They actually have the opportunity to go right to being a broker, but they got to take the broker course in full and pass it, right? That's just the way it works. Okay, so I just want to make that clear. Then you want to be able to identify qualifications for a sales associate license, and this is what you need to be have qualified to be able to get approved. And you must be 18 years of age or older, high school diploma or equivalent, possess a U.S. Social Security number, be honest, truthful, and trustworthy, of good character, competent and qualified. And you must disclose if you had any convictions, pleas of no contest, or under investigation. Any other names or aliases, that includes maiden names before marriage. Had any disciplinary action taken against a professional license. If you're ever denied a real estate license in Florida or any other state. Those things are what you need to qualify. Now, let's describe the education requirements for post-license education and continuing education. So licensees who get their sales associate license must complete the post-licensing course before the expiration of their initial license. So they have a 45-hour sales associate course. They must pass the end of the course exam with a 75% or higher, and they can retake different tests one time. So they can fail it and retake it one time, or they have to take it over again. And then after that, your first license renewal, when you do the 45-hour, after that, moving on, you have to continue education at 14 hours every 2 years for each 2-year licensing period. And of that 14 hours, you have 3 hours of core law, and they may earn 3 hours of specialty credit by taking core law each year, 3 hours of business ethics, and 8 hours of a specialty credit. So you can take 2 4-hour classes of anything or 1 8-hour class of anything. But that's the minimum you have to take. You can take more, but that's the minimum. Okay. Next, you have to identify the qualifications for a broker license. Okay, Florida licensed sales associates must complete their 45-hour post-license requirement from their initial license. They must complete the 72-hour FREC course 2, which is the broker pre-license course. Like you're taking the 63-hour FREC 1 course now. The FREC 2 course would be the one for broker. Now you must have an active sales license, 24 months held in an active real estate license in the previous 5 years. So you can have a sales license, but it's got to be active for a continuous 24 months in the last 5 years. So as a sales associate working for a Florida broker or for a broker in another state, you could have that same 24 months in any of the 50 states, right? Or actually international too. You don't have to, it doesn't have to be in the States. It just has to be 24 months as a licensed broker, right? Or a sales associate. Now, as a sales associate working for a government agency, so you could be working for a government agency as a real estate associate, or as a broker in another state or nation, as long as it's licensed. You must pass the state administered license exam. And then after you pass that, you have a 60-hour broker post-license course. So you have to take the 60-hour post-license course, just like you did a 45-hour post-license course. Then after that, you got to take 14 hours every 2 years, just like the other one. Okay. Now let's distinguish between registration and licensure with the DBPR. Okay, registration is placing on record with the DBPR the name and address of each licensed broker or sales associate, name of the business address and sales associate's employer, active or inactive license status, and broker involvement in a real estate entity. Okay, so what you have is licensure is when you have a license, a sales license or a brokerage license. Registration is when you have partners on a business and not all of them are licensed. So whoever's licensed obviously is licensure. Whoever's on the business as a partner and does not have a license would be registered, right? You register them with them. Do you understand the difference of that?
That one seems to be a little tricky.
Right.
Do you mind cover that again, please?
Sure. So if you opening a real estate brokerage and you have 3 partners, one of them has a license and the other 2 are just, or the other 3 are just investors and they're just partners. One's going to handle sales training, one's going to handle marketing, one is going to be office manager, right? And then there's one that has a license who's going to be the qualifying broker and handling brokerage activities with the agents. So the one who's licensed is licensed and also qualifying broker. The 3 partners who are not licensed, they have to be registered with the DBPR, with the state. So even though they're not licensed, they still must be registered. Do you understand that?
Yeah, and what does it mean by being registered? Like, what do you do? How do you register?
Registered is I mean, they're put on the paperwork, their information is given, they're just not licensed. They cannot perform duties, they can't show property, they can't do any licensed activities. They can be an owner, but they cannot perform any licensed activities.
Okay,
You register them on the paperwork, yeah, on the company and with the DBPR.
got it.
All right. Now let's look at to identify real estate services that require a real estate license and exemptions for those licensure. Like I was just saying, if those partners don't have a license, they couldn't do any of these, right? They can just do the training, the marketing, the office management, right? So a bar sale is the acronym for it. So when you have a license, you're able to do these. If you don't, you're not. So you have to have a license. It's required to do this. To advertise real estate services, to work with buyers, to appraise non-federally related transactions, to work with people renting or provide rental information, to sell property with people and have clients, auction property, lease property to people, and exchange property for people. All those items you need a real estate license. However, if you're doing it for yourself, you don't, right? If you're involved in a transaction, you don't. But the minute it's a third party, you must be licensed to do that. Okay. And there's 5 general groups of exemptions. You have one owner exemption. I just said that. If you own the property or you're involved in the sale of a property, you may buy, sell, exchange, or lease their own property. That's for individual property owners, officers, directors, and corporations and owners of the businesses. So if a business is owned the property, the person who owns the business can do it. Partners in a real estate partnership, if the partner only receives normal prorated shares of profits. So if there's 4 partners and they're all split 25%, you don't need a license. If there's 4 partners and one is 50% and other 25 and 25, you're going to need a license because there's unfair advantage for the person, right? They have more experience and they want you to be licensed, so there's nothing that's done, underhandedly. And then also owners of timeshares. If you own your own timeshare, you're able to do that and sell that, right? Now let's look at exemptions based on careers. Okay, so attorneys at law acting in the attorney-client relationship. Okay, a Florida attorney license does not entitle attorneys to compensation for performing real estate services. They can perform them, but they can't charge for those real estate services if they're not licensed. A CPA, when performing accounting duties. State certified and licensed appraisers when conducting appraisals. Okay, and number 3, salaried employees exemption. Okay, so if these employees are paid a salary and do not receive commission or bonuses on a transactional basis. Anyone who buys, sell, exchange, or leases property for their business employer, who work in an apartment on-site rental office in a leasing capacity, who are managers of a condo or cooperative apartment units, who rent units for periods no longer than a year, or if they work for an owner-developer, which is a real estate developer, and do not receive commission. Those salaried employees are exempt. Okay, and let's look at number 4, court and legally appointed persons. Okay, so if a court appoints an individual, the personal representative is these are the examples. So the court will be appointed. So if you have a person who is designated in a will to handle the transaction, and that would be like an executor of an estate. Okay, and then you also have attorneys in fact. Okay, attorneys in fact are a power of attorney, and for that purpose of signing a real estate document, so they can handle that document and that's it. It's a single purpose power of attorney. Okay, power of attorney cannot be used to authorize an individual to conduct real estate services. Now, what that means is you can't have a power of attorney to do a listing agreement, and you can't have a power of attorney to do a contract for either party. They have to do that. However, you can have a power of attorney to close the deal. They can sign the closing documents. Okay, they can sign the deed, right? But you can't initiate a transaction with a power of attorney. Okay, so let's look at some miscellaneous exemptions. Okay, so individuals who rent lots in a mobile home park or travel park, persons who sell cemetery lots. You remember the question we did in our review, right?
Yeah, I do.
Yep, registered security dealers selling businesses at businesses enterprises, hotel and motel clerks who rent transient lodging. That'll also include Airbnb, right? And
Yep.
then also what you want to remember is the finder's fee for tenants. It's the only time a fee is allowed to be paid, and that's when a landlord owns a building and he has empty units, and he tells the tenants, if you find me somebody for a unit, I'll give you a $50 finder's fee. You can't give more than $50, and that's the only time that that's allowed. Okay. Now I want to go into section 3. Okay, section 3 has 2% of the questions on the state exam. So you'll have 2 out of 100. And unit 3 is about real estate license law and commission rules. Okay, so the first thing you want to be able to identify and understand is how to describe the function, the scope and function of the DBPR and the DRE. So Department of Business and Professional Regulation, that's the DBPR. They're under the executive branch of the state of Florida. The chief administrator is the secretary of the DBPR. They're appointed by the governor, subject to Senate confirmation. You got to remember, they're always appointed by the governor, subject to Senate confirmation, not FREC confirmation. They're not appointed by the Senate and confirmed by the governor. They're appointed by the governor and subject to Senate confirmation. Okay, licenses, they license and regulate businesses and professionals. They're granted legal powers by legislature. They investigate complaints, issue subpoenas, issue cease and desist orders, issue citations. Okay. Now the divisions under the DBPR, you have the divisions of professions, the divisions of service operations, divisions of Florida condominiums, timeshares, and mobile homes, and the division of real estate, the DRE. Now there's a division director for the DRE. Anybody who works for the DRE are actually employees of the DBPR. They provide services needed to administer real estate law. Okay, it's administrative and ministerial. So they're basically record-keeping duties as well. And their office is located in Orlando. Okay. So let's describe the composition and member qualifications of the Florida Real Estate Commission. Okay. So there's seven commissioners. Okay, and it's broken down. There's 5 professional licensed members. Okay, 4 must have held a broker license for 5 years preceding appointment. 1 of them must either be a licensed broker or sales associate who has been active 2 years preceding appointment. And then you have 2 consumer members who are never licensed. And 1 of the 7 commissioners must be 60 years of age or older. So what they're doing is they're taking people who have 4 of them have experience, 5 years. 1 has a little bit less experience. And then 2 are people who do not have any experience. And 1 of them must be 60 or older. The reason they do that, they want to keep it diversified. They don't want to have all, one type of people. So things can be heard and discussed and voted on, right? By a diverse group of people who represent the community, right? That's why they do it that way. Now, you want to describe the commission's general powers and duties. You want to be able to understand this and how it works. So they have executive power. Okay, they can regulate and enforce license law. They foster education. So all the programs and all the schooling, they handle all of that. They adopt and seal prima facie evidence. So that's evidence that, is proven on its face. So if somebody has a real estate license, the real estate license is the proof they have it, right? So they adopt and seal that. And they establish the fees for licensing and fines and all that stuff, right? They're quasi-legislative. They enact and revise administrative rules and bylaws. They promulgate, which is adopt the rules and bylaws into effect. And then they regulate professional practices. They're quasi-judicial. So that means they can grant and deny applications, suspend or revoke licenses, and issue administrative fines. They make determinations of violations. They inform the division of Florida condominiums, timeshare, and mobile homes when any disciplinary action is taken. You remember seeing that on our practice exam, right? That concept.
Yeah.
The FREC's activities are limited to administrative matters. So they're handling all administrative matters, and that's all they're limited to do. Okay. So you need to distinguish between what an active and inactive license status and describe the regulations regarding involuntary inactive statuses. So the first thing you need to know about this is an active license is required to perform services of real estate for compensation. Voluntary inactive status. This is when a licensee requires inactive status. It's voluntary inactive licensees must complete education and renewal requirements. So they can be current inactive, but they still need to do their 14 hours and their education is submitted, because if not, they're going to go involuntary inactive, right? They must keep that up. So involuntary inactive status is when you fail to renew the license before the expiration date. After 2 years, an involuntary inactive license is null and void. Right? Remember, we had a question like that, right? Involuntary inactive status reactivation education. So if you're inactive, involuntary for 12 months or less, all you have to do is complete your 14 hours continuing education course and you'll be reactivated. If it's more than 12 months, but less than 24 months, you must complete a 28 hours of prescribed reactivation education courses. And once you do that, you can be reactivated. But if it goes over 1 day, more than 24 months, you lose your license, you're null and void, you got to go back and start over. Okay. Now let's distinguish between multiple and group licenses. You remember seeing something on this, right? When we did our exam, right? Practice exam.
Yep.
Multiple licenses are issued to a broker who qualifies as the broker for more than one business entity. So for example, I'm the broker owner and qualified broker for Pier 21 Realty. If I want to open Pier 22 Realty, Pier 23 Realty, Pier 24 Realty, I can do that. I would have multiple license. I would be the qualifying broker for each business. There's no limit to what you can do that way. Okay. So for each business that a person is a broker, or a separate broker license must be obtained. Sales associate and broker associates are registered under one brokerage entity. So you can't have, like, if I have agents working for Pier 21 Realty and I had Pier 22 Realty, they can't work for both. It has to be, they can only be with one brokerage, right? Okay.
Got it.
Now, a group license are issued to sales associates and broker associates who register under an owner developer, a real estate developer. Okay, this is when an owner developer has multiple developments being built. Okay, and the owner developer sends a DBPR, a list of the legal company names with the same ownership. The sales associate or broker associate has one license, one employer, the developer, and then they can work any of the developer's sites. So they can go from site to site and sell those properties. However, they can't go outside of that and sell properties or list properties. They can only work for that broker, right? Or that developer, I'm sorry, that developer. All right, and that's unit 3. Let's take it, what we're gonna do now is we're gonna take a 10-minute break and we're gonna come back and we'll start with unit 4. Okay, now we are gonna start unit 4, which is authorized relationships, duties, and disclosure. And on your state exam, you're going to see about 7% of the questions. So you'll have about 7 questions from this unit. Okay, so what we want to do, first of all, is to distinguish among agency relationships in general business dealings. So you have a principal. Okay, the principal is who delegates authority to another. That's your seller, that's your buyer, right? They're delegating authority to you, right? Then you have the agency. Agency relationship creates a fiduciary relationship. Okay, it's an unrelated relationship. It's opposite of an arm's length transaction. Okay, and the warning is caveat emptor. It's buyer beware. Okay, now there's 2 types of agents in general business dealings. Okay, agents are persons who is authorized to represent and act for a principal. Okay, you have a general agent who handles everything, and you have a special agent who handles a primary role, right? So you have general and special agents. Okay, now we need to be able to describe the 3 brokerage relationship options. Okay, so the first option is a no brokerage relationship. That's where there's non-representation. The seller or buyer can choose to opt out of this representation. The broker will facilitate the sale and purchase and may not negotiate or work on behalf of the customer. Okay. Then you have signal agency. This is where a broker who represents a principal as a fiduciary, either a buyer or seller, but not both in the same transaction. In Florida, that would be dual agency, and it's illegal in Florida. Okay, so you can't have those duties owed to the buyer and the seller. So if you have a seller and you're in a single relationship, the only way you can represent that buyer would be in a no brokerage relationship because you have no duties to them, right? None of those specific duties, fiduciary, right? The other option is you'd be able to transfer. Like you could be a single agent with the seller, use a transition to transaction broker and be a transaction broker for the buyer. And now you can work for the transaction, which we're going to talk to in a second. That's one option. But legally, if you're a single agent for the seller and you're not changing your status, the only way to represent the buyer would be as a no brokerage relationship, or they would have to work with another brokerage. Okay. Now let's look at the transaction broker relationship. This provides limited representation to the customer or the client, right? The customer is the buyer, the client's the seller, right? That's a rule of thumb. So a buyer, a seller, or both. You do not represent either the buyer or the seller as a fiduciary or as a single agent. You're representing the transaction. And the customer and the client is not responsible for the actions of the broker. So they're acting on their own behalfs, right? So let's describe the duties for each of these relationships. So describing the duties owed in a no brokerage relationship, this would be non-representation. You have 3 duties. You have, the acronym is ADD, account for all funds, deal honestly and fairly, disclose all known facts that materially affect the value of residential property that are not readily observable to the buyer. These 3 duties are required in all types of brokerage relationships. So all 3 of them have these standards. These are the minimum standards for all 3. Okay. Now let's look at the duties that a single agent has in addition to these. So again, they have ADD, account for all funds, deal honestly and fairly, disclose all known facts that materially affect the value of residential real property that are not readily observable. Now, what does it have in addition? You must use skill, care, and diligence, present all offers and counteroffers, confidentiality, obedience to the point you're not doing anything illegal, right? Obedience, you got to listen to them, but you cannot do anything illegal. Loyalty to them, and full disclosure, anything at all, right? All information has to be disclosed. Now let's look at the duties that are owed in a transaction broker relationship. Again, you have ADD, right? Account for all funds, deal honestly and fairly, disclose all known facts that materially affect the value of real property not readily observable. You must use skill, care, and diligence in the transaction, and timely present all offers and counteroffers. That sounds familiar, right? Because the single agent has that too. Interesting. So they both have ADD, they both have skill, care, and diligence in presenting offers and counteroffers. However, there's 2 here that the single agency doesn't have. And that's exercise limited confidentiality unless waived in writing by a party, and perform additional duties mutually agreed to. Now, the way you can remember that, in a single agency, you have obedience. You must listen to them. You don't have limited, and you have confidentiality. You don't have limited, right? So you must, here you can exercise limited confidentiality. As a single agent, you must exercise confidentiality and perform additional duties as agreed to. You must have obedience in the single agency. Here, you can perform additional duties if you agree to them in writing on the listing, right? So if a client says to you, I don't want people walking through my unit with their shoes on. So you can either put plastic booties on or take your shoes off, right? That's something you can agree to in writing. Now, if you're a single agent, you must do that. Like, you don't have a choice, right? Okay. Now let's describe the process from transition from single agent to transaction broker. So if you have a listing and you're a single agent relationship may be changed to a transaction broker relationship. So if you have somebody that says, hey, I want to look at this house, you cannot legally show them that house unless they sign. If you're a single agent, you list a home. Somebody says, hey, I want to look at that home to you or anybody in your brokerage. You cannot legally show them that home unless they sign a no brokerage relationship or you transition to a transaction broker. So you go to the seller, hey, can we transition to a transaction broker? I have a buyer wants to look at your house. The seller can say no. And then they'd have to sign no brokerage. You got to tell them to go somewhere else and have an agent show them the house, right? That's what happens. So if the seller says yes, there's a form. You transition to a transaction broker, you sign the form. Now you're transaction broker for both, right? And then they do the consent. and then you show the property, right? Good. All right. Now, if you want to be able to describe the disclosure procedures and the required content and format of the disclosure notice. So written disclosures are required in residential transactions when operating in a single agency or a no brokerage relationship. So if you're being a single agent or a no brokerage, there's a disclosure. Okay. A residential sale is defined as improved property of 4 or fewer units, unimproved property zoned for 4 or fewer units, residential units, agriculture property of 10 or fewer acres. Okay, duties must be described and disclosed in writing if you're a single agent or a no brokerage relationship. If you're a transaction broker, no, because in Florida, you're presumed to be a transaction broker. So if you don't have a single agency or no brokerage, you're presumed automatically transaction broker. Okay, so there's no form for that one. Okay, it can be included in the listing agreement. Okay, so if you're going to list a home, the disclosure for single agency must be in that listing agreement. Can't be after that. You can do it before, or you can do it up to the listing agreement. If it's dated after it, you broke the. It's not. You broke the laws. It's too late, right? A single agent disclosure before or at the time of entering into that listing agreement, or before showing property. The no brokerage notice must be before showing property. So if you have a listing and it's a single agency, and you're going to show that property to somebody, they must sign that no brokerage agreement prior to walking in that door, right?
I have a question.
Sure.
So when it comes to the definition of residential, like I'm a little confused when it comes to that, because just now we're saying that a residential sale is when the units are 4 or fewer, whether they're unimproved or they are improved, whatever the case may be.
Yeah, if it's built or not. If it's
For
just
agriculture,
Yep.
what is it?
Yeah, no, go ahead. So if it's built or not, yeah, you froze up there for a second. So if the land has 4 or fewer units on it, or it's zoned for it, it's just flat land, that's considered residential. So go ahead.
Gotcha. But previously we were saying that everywhere where people reside, it's considered residential.
No, anything 4 or fewer units is residential building zoning. Anything 5 or more units is commercial. Is commercial. So if it's an apartment complex of 100 people, it's commercial. What you're confusing it with is the depreciation on tax. So when you have a property and it's residential, it's 27 and a half years your depreciation. When it's commercial, it's 39 years. The IRS, for tax purposes, if people live in it as a home, it doesn't matter if it's 1 unit or 1,000 units. The IRS considers that residential, and that'll be 27 and a half year depreciation. If it's a business, you understand. So for loan purposes, for residential zoning purposes, 4 or fewer units is residential. The minute you hit 5 units and up, it's commercial for zoning, for lending purposes, right? You know, for all the discrimination laws, all that is residential, 4 or few units. Now, when you go up to 5 units or more, the IRS sees that as residential if it's 1 unit or 100 units. So don't confuse the depreciation calculations with the classifications for zoning.
Okay.
Does that make sense now?
Yeah. So 4 or fewer units, it is considered residential, but that's only with lending.
That's with lending. That's with zoning.
Lending and zoning. Okay.
Right. So if you go to buy a house and it's 4 units and you're going to live in one of them, it's treated as a single family home. It's treated the same, 1, 2, 3 units, 4 units for lending purposes. However, you're able to use those leases, 75% of the value, towards your income for those units.
Yeah, to get approved for it. Yeah.
Right. So that counts towards your income for your debt ratio. So that's what, don't confuse tax depreciation for the IRS for income properties, right? That makes sense?
And the lending. Yeah, I got you. So
Right.
there's
Because for
lending and zoning.
tax purposes, it's either residential or commercial. There's no split on that, right?
Oh, okay, got you.
Because you got to think about it. Tax wise, first of all, it's not owner occupied. When you're doing depreciation, it has to be an investment property. So it's either a single family investment, duplex, triplex. There's no ownership. There's no living in that because you can't depreciate the property you live in.
Got it.
It's only for investment property. So
Only
that
for
just
investments.
don't get that confused. I know how it's easy to get it confused, but once you start doing it, it's like a wall between it. Okay.
Got it. Okay.
You got it. Okay. So 4 or fewer units, building or land is residential. Okay. 5 or more is up. Good.
Got it. Mm-hmm.
Okay. So these duties must be described and disclosed in writing with the forms. Okay. That's what you need to know. And like I said, before you show property where you're a single agent in the listing, you must have a no broker's notice signed before you show it. Okay. Or you break the law. Okay. Let's look at the types of transactions that do not require disclosures. Okay. So the disclosures we just talked about, I just told you the transactions that need them, right? So let's look at the ones that don't need them. So anything that's non-residential, okay, non-residential transactions don't have disclosures. Rent or lease agreements don't have disclosures. Except options. When you have an option contract, there is a disclosure. Disclosures are required. Business opportunities, when it's 4 or fewer residential units, as an exception, right? So business opportunity. If you're buying a 1 to 4 unit property as an investment, you do need disclosures. However, if you're buying a pizza shop or a restaurant or something, these disclosures are not required. Auctions, real estate auctions, and also when appraisals are done, there's no disclosures. Okay. Now, let me describe the disclosure requirement for non-residential transactions where the buyer and seller have assets of $1 million or more. This is the one time in Florida where you're allowed to have dual agency. So when it's non-residential, the buyer and seller agree, and they have 1 million or more in assets. There's something called a designated sales associate. So you can have a brokerage with a single agency listing for non-residential, okay? And a buyer says, I want to be represented single agency for privacy and for, disclosure. In that case, a broker can designate 2 agents, and they need to complete a designated sales associate form. And at the request of the buyer and seller, that broker may designate the sales associates to act as single agents for different customers in the same transaction. The buyer and seller must have assets of $1 million or more and prove it. Okay. And the written disclosure would be you have to have a single agent disclosure for each, the buyer and the seller, and also a designated sales associate disclosure for the buyer and the seller. And that would be legal and that would be allowed, but only non-residential, $1 million or more in assets. And they have to agree, buyer and seller. You good on that?
Yes.
You need to understand that. Okay.
Yeah, I do.
Okay. Now let's list the events that will cause a brokerage relationship to be terminated. So you have a brokerage relationship. How does it end? Number 1, fulfillment of the brokerage relationship purpose. So if the contract closes, right? Deal closes, is dead. It's over. Mutual agreement to terminate. Everybody decides, okay, let's just end the agreement. Okay, it's done. Expiration of the agreement. The time runs out. Okay, the broker renounces the relationship by giving notice, or the principal revokes the relationship by giving notice. Death of a broker or principal, destruction of property or eminent domain, and bankruptcy of the principal or customer. So the seller or the buyer goes bankrupt. That'll kill the contract. There are your ways the contract can be terminated. You need to know those as well. Okay, now let's go to Unit 5. This is one of the largest units on the exam. 12% of your exam comes from this section of the class of the review. Okay, so Unit 5 12 questions, 12%. It's about real estate brokerage activities and procedures. It's how the operations work. It's how everything's done. Okay. So what you need to know, you have to be able to identify the requirements for a broker's office and explain what determines whether a temporary shelter must be registered as a branch office. So remember, it has to be an enclosed room in stationary construction. Okay. It doesn't have to be its own building. It could just be an office within an office, or an office within a building, right? Brokers must keep their records in the office, and they can be digital. Okay, office may be in the broker's residence, verified that the zoning and HOA allow it, if they're in an HOA or zoning. Okay. Like our building for our brokerage in school, it's zoned commercial, residential. It could be a house or a brokerage. It's zoned that way where we're located. It's private. It's not in a community. It's on a main road. Okay. So when I did that, for example, when I got my license in Tennessee, I had to send them the zoning to show them that it was commercial before they would allow this firm to be licensed in Tennessee.
Got it.
Okay. May have offices in another state, which we do. Sales associates may not open and register an office of their own. Sales associates may have an office in their home and use that as tax deduction and stuff for their taxes, but they cannot bring clients there and they cannot advertise that office. A broker must register each branch office. Okay, branch office registrations are not transferable to another location. So for example, if I want to move my school and brokerage, this is my main office, I can move this license. However, if I open an office in another city and I say, okay, I want to take that office and move it to another city, you can't transfer that. You have to close that office and get a new license for the other city. Does that make sense?
Yeah.
You got to remember the difference of that. You can actually move your main one, but you cannot move a branch one. Okay. All right.
Got it. You need a new license for that.
Yep. Now, temporary shelter, not a branch office, unless sales associates are permanently assigned or sales transactions are closed there. So if there's a development or a building and they have temporary like buildings outside or mobile homes or mobile offices, they do not need to be licensed unless you have people assigned there schedule wise, like so many hours a day, and that deals are not closed there. If it's closed there or you're scheduled there, you must have a license. Okay. Go there. There we go. What page was I on? I think I just slipped through. There we go. That's better. Okay. All right, so we're here. Okay, good. Now you got that. So temporary shelter is not unless they close the deals there, right? We just talked about that.
Yep.
Let's look at the next. So now we need to list the requirements related to sign regulations. Okay. So if somebody's a sole proprietor and they're using a trade name, okay, the sign must have the trade name, if there's one used, the broker's name, and the words licensed real estate broker or LIC period real estate broker. Okay, the names of the sales associates and broker associates are optional. If they're included, the names must not appear misleading, false, or deceptive, or fraudulent. Okay, if the brokerage entity is a partnership, corporation, or limited liability partnership company, the sign must contain the following: the name of the firm or corporation, the name of at least one active broker, and the words licensed real estate broker. You cannot put LIC period. It has to be licensed real estate broker. Okay. Now we need to list the requirements related to the regulation of advertising by real estate brokers. Okay, so anyone who advertises or claims to be providing real estate services is acting as a broker. So if an agent is running an ad and they run that ad and don't have it approved by their broker, or they're running something error, the broker is responsible. The broker gets in trouble, and so does the agent. So advertising must inform people that they are dealing with a licensee or a brokerage firm. The broker is responsible for all advertising. They can't say, I didn't know they ran that ad. What do you want me to do? Nope. I have a policy where all ads have to be approved by me before you run them. And I just put into effect, if you run an ad without my approval, you're immediately removed and you're fired. Like you're not working at the brokerage anymore because of that. So I actually, there's no chances. There's no, oh, I made a mistake. It's very clear. It's made very clear when I hire people. If they do it, I'll deactivate their license. Then I'll tell them. That's how I'll do it. Like I won't even wait. Right. So it must, so that's the important thing. It's going to affect, the brokerage if somebody does that, All right. So let's talk about, let's see. Okay. Let's talk about the ads. So the ads must have the logo, name of the brokerage. Like, I have a logo that must be in every ad. It's a standard logo and it's what's required in all 3 states. So Florida requires things, North Carolina requires things, Tennessee requires things. Some of them require different things. So I made one logo with everything for all 3 states in it. So in some states I have too much, and some states I have, what they need. So I just have one logo, because if somebody from another state sees my logo and says, hey, this isn't, it's what it is. It's one logo for everything that must go in all advertisement. Okay, so let's talk about team advertising. Okay, the name or logo used by one or more licensees who represent themselves to the public as a team or group. The team concept allows broker associates and sales associates to join forces to serve a wider group of customers more efficiently. Teams must advertise in the name of the brokerage firm. Okay, a team must file with the employing broker the name of the licensee whom the team designates to be responsible for ensuring team advertising complies with license law. The registered broker must at least meet monthly with the team and maintain the record of the team members, who's on the team, who's off the team, who's on the team as they bring people and get rid of people. Okay. The team name and ads must be no larger than the name of the registered broker. Team advertising rule applies to all forms of advertising by the team: social media, print, paper, whatever they do. Certain words are not allowed in team names. Okay. So the word agency, associates, broker, brokerages, company, corporation, corp, Inc., LLC, LLP, LP, partnership, properties or property. The word real estate or realty cannot be in the team name. Okay. And then there's something called blind advertisements. This fails to disclose the name of the brokerage firm and includes only a PO box, telephone number, and or a street address. Blind advertising is illegal for licensed realtor. It's illegal. Okay, you can't do that. Let's look at personal information advertising. Okay, licensees may use their personal name in ads, provided it's included their last name as registered with the DBPR. Yard signs and classified ads must include registered name of brokerage firm. Promotional materials must have the name of the brokerage firm. The sales associate's name must also appear. Internet advertising. Point of contact information is the means to contact the brokerage firm or a licensee, including mailing address, street address, email address, telephone, or fax number. Brokerage name must appear adjacent or immediately above below point of contact information. Okay. That's what we were talking about. You asked me a question about that yesterday, I believe, when we were going over the practice exam, right?
Yes, we were.
Right. Explain the term immediately as it applies to earnest money deposits. So when you get a deposit, like, see, today, a lot of people wire money. Like, for example, we just put a deal under contract. They wired the money. I got the letter today. They wired the money yesterday. I got the letter today saying the money's in the account. So the escrow company sends a letter, escrow deposit letter. Today, you don't get checks so much, but you need to know this for license law. So if somebody's putting a $10,000 deposit down, they write you a check for $10,000, right? The sales associate and broker associates must deliver that no later than the end of next business day. You get it on Thursday, by the end of Friday. You get it on Friday, by Monday, right? You get a check, people do it immediately, like right away, but you have that time legally. Now, the broker must deposit in the escrow account no later than the end of the third business day following receipt by the brokerage. So the day that the agent gets it, says Monday, that's day 0, right? The broker, so Monday, and Tuesday's day 1, Wednesday's day 2, Thursday's day 3, right? That's how that works. That time coincides with the agent getting it to the broker. Okay, clear on that?
Yes, sir.
Okay. Now let's describe the 4 settlement procedures available to a broker who has received conflicting demands or who has a good faith doubt as to who is entitled to disputed funds. Okay, the acronym is MAIL. You have mediation. Mediation is informal. There's a neutral party and they negotiate a settlement. Arbitration is binding judgment by a third party, and this has prior consent of the parties. So they both agree, we're going to go into this arbitration. The person who's doing the arbitration is going to decide, and we're going to follow what they say no matter what, even if you lose, right? And then you have litigation. Okay, there's an interpleader. That means the broker has no financial claim. They're just involved in it. They're holding the money if it's in their escrow account, right? And then the judge makes a declaratory judgment, and the judge declares each party's rights to the funds. One party can get it all. He can make them split it. He can do whatever he wants, right? Or she. And then you have the escrow disbursement order. That's the EDO. You'll get that from the state. They'll give you an escrow disbursement order. And the broker must follow that EDO. Okay?
Question. So when it comes to this settlement procedures, is that something that is specified in the sales contract way prior to the issue arising?
It's actually in the contract. Yeah, it's actually in the contract. Yep.
Gotcha. Okay.
It's actually the settlement procedure is actually in the contract. The contract has information about it. Now, they can choose what they want to do. Now, this only happens when the broker is holding the escrow. If the title company is holding the escrow, this never happens, right?
Got it.
Got to remember that.
All right.
If the broker is not holding the escrow, they can go right to litigation, right? They can still do mediation. It's all in the contract. But, you know, the title company will not release it until, you know, they both agree or a court order, right?
Makes sense.
Okay, so now we got to explain the rule regarding the advertisement of rental property information or list on negotiation of rentals. Okay, licensees who furnish rental information for a fee must provide a receipt with provisions for repayment. Okay, now as of January 1st, this information was removed from the exam. However, I'm still teaching it because students are telling me they're still seeing it. So again, this is coming off. This no longer applies, but you need to know this in case you see a question about it. Okay. So the licensees who furnish rental information for a fee must provide a receipt of the provisions. Okay. They must give 100% refund if the rental information is not current or inaccurate. 75% of the fee paid if the customer does not find a rental. You must return that. The refund must be requested in 30 days. If they wait 31 days, they don't get it. Okay. It's a first-degree misdemeanor for selling out-of-date or inaccurate rental information. Now, the reason this doesn't apply anymore, can you imagine printing out rental information and handing it to somebody? By the time you hand it to them, it's already inaccurate because another one went on the market and 2 of them went under contract in that 15 minutes, right? Technology has surpassed this. You know, like no one, like you can't give anybody accurate information. It changes every 5 minutes when rentals change, right? Yeah. So everybody be criminal if they did that.
Everybody.
So that's why it's gone away. But it's still, if it pops up, you know, if you see it on your test, let me know. You know, as people start not seeing it, then I'll remove it from the teaching. But okay.
Makes sense.
Next, we have to describe the regulations regarding lien rights for unpaid sales commissions. Okay. So only brokers, not associates, can seek compensation from buyers or sellers, right? Because the broker's agreement is with the buyer and the seller. The agent is the authorized person, right? Liens on residential property for non-payment of commission. It's only allowed if the broker is given the authority in the listing contract. Otherwise, they have to seek civil judgment, go to court and sue them.
You see, that's what I remember. That's why I
Yep.
chose what I chose. But I just now see
This is residential.
that.
This is residential.
But not only that, the broker has to be allowed
Mhm.
in the listing contract.
Yeah, it has to be.
Therefore, the answer for that most of the time is going to be to file a lawsuit.
Yeah, yeah.
Yeah.
Now, here's an example. If you're listing a $3 million property and the commission's 180 grand, you could put in a contract, I'm going to put a lien against the, commission off the proceeds. That's a lot of money. Somebody wants to fight you on that. You know what I mean? And most people will agree. The lien goes on and then you get paid at closing. It clears the lien, right? So it just depends,
Wait,
it depends. Like on a normal transaction, I've never really used them. So personally, but on commercial business, I would. On any commercial deals, you put a lien. But when residential, I mean, unless it's something significant and you think you're going to have a problem, because you got to go to court, it's going to take time and money. It's just, if it's a super huge thing or you don't trust somebody or something doesn't seem right, you have the right to put it in the contract, So
I got it. But even then, I think we learned something referring to where the lien should go, because in order for the sale to be processed, the deed has to be clear.
right, yeah. So like on this, it may not encumber the title of the real property. So you'd have to put it on assets. You'd have to put it against them personally.
Another property.
Residential deal, you can't put it on the property that you're selling. Correct.
Yeah.
On commercial, you do. It goes on the proceeds.
Got
So,
it.
okay, so it may not encumber the title of the property because you can't stop the sale from going, right? For that.
Yeah.
Okay, now when it comes to commercial, right? Chapter 475 Florida Statute Part 3 is about commercial, right? And that's about the liens for, sale of commercial property, right? Chapter 4 is lease of commercial property. So 475 Part 3 about the sale liens, it gives the broker the lien rights on seller's net proceeds from the sales of the property, not lien rights on the property. So if they're making $2 million and your commission's 200,000, you put the lien rights on the property's profit, not the property. Does that make sense?
Yeah, makes total sense.
Okay, now on a lease, it goes on the property. If it's a lease you're doing for the landlord who owns the building, that lien would go on the property because the property is not transferring. It's leasehold, right? It's a leasehold, not a freehold,
makes
right?
sense.
So the broker's agreement, the listing contract must clearly state the broker's lien rights if you're putting liens on. Okay. Now let's look and contrast the features and requirements of the various types of business organizations. Who can get a license, who can't, right? So a sole proprietor can be licensed, right? It's owned by one person. The owner has full liability. The owner must hold an active broker license, and they must register under their own name or a trade name. Okay. General partnership, 2 or more partners engaging in business together, created by written or oral or implied agreement. Each is liable for the partnership's debts and can bind the other partners in contracts. Real estate brokerage general partnership. It's registered partnerships with the DBPR. At least one partner must be an active broker, right? So if one partner is an active broker and the other isn't, the active brokerage is licensed. The other one is registered, right? Like we were talking about the difference. Partners who deal with the public and perform real estate services must be active brokers. Sales associates may not be general partners. Limited partnership, created by written instrument filed with the Florida Department of State. 1 or more general partners and 1 or more limited partners. Limited partners make invest of cash or property, not services. Right? So limited partners are just the money behind it. They're not handling the business. Okay? Limited partners have limited liability. Okay, real estate brokerage limited partnership. It's registered limited partnership with the DBPR. General partners who perform real estate services must be active brokers. At least one general partner must be an active broker. All other general partners must register with the DBPR. Don't have to be licensed. They must register, right?
Yep. Question for you.
Mhm.
So the sole pro- proprietorship, I don't know how to say that. For
Sole proprietorship, sole proprietorship.
that thing. What? How do you say the one with the church, like the one for the church?
Oh, we're gonna get to it. We're gonna get to it. We're not there yet.
I know, but my brain
That's
just
coming.
hits it right now.
That's a corporation sole.
Oh, corporation sole, as opposed to a sole. Okay.
Yeah, corporation sole cannot be a brokerage. Remember, that's a religious entity.
Yeah.
Sole proprietorship is just one person acting as themselves, trade name, social security number, no business, right? No,
Got it.
no separate entity. Okay. All right. So also to finish up the limited partnership, sales associates may not be general partners. However, sales associates can be limited partners. They can be investors, but they cannot have any company making decisions, right? And the limited partners do not register with the DBPR. The general do. The limited partners do not. Okay. A limited liability partnership. This is protection from personal liability. Partners are not subject to limitations imposed on limited partners, as in a traditional partnership, limited partnership. The name of the limited liability partnership must include registration, limited liability partnership, or LLP at the end of the name. Okay. Then you have corporations. Okay. Corporation is an artificial person or legal entity created by law. They file the article of incorporation with the Florida Department of State. Foreign corporation is organized under laws of another state, and they may do business in Florida. Domestic corporations are incorporated in Florida. Okay, managed by board of directors and officers, and it may be for profit or nonprofit. Okay. Okay. Any questions on that?
No.
Okay. Then we have Real Estate Brokerage Corporation. They register, it's a registered corporation with the DBPR. At least one officer or director must be an active broker. Okay, active and inactive brokers and unlicensed people may serve as officers and directors. Okay, they must be active brokers to perform real estate services. Unlicensed officers and directors must register with the DBPR. Sales associates may not be an officer or director. Sales associates may be a shareholder. They can have stock and invest, but they cannot be an officer or director. And last is a limited liability company. This has the best features of a corporation and a partnership. You have protection from personal liability, and the IRS treats the LLC as a partnership for tax purposes. Income is taxed only once as in a partnership. So when you're a company, you get taxed on the income and you get taxed second on the profit, like what's left over. You don't have that in an LLC. Okay. There's only one taxation. Okay. Do you have any questions on Unit 5? This is the end of Unit 5.
Oh no, I don't have any questions. No.
All right, good. Okay, let's look at Unit 6, which is violations of license law, penalties, and procedures. Okay, so you're going to have 2% of your state exam on this unit. So that'll be 2 questions out of 100. So what we need to do is to distinguish among the legal terms presented in this unit. So the terms you need to know is breach of trust, that is breaking of a promise or obligation. Concealment is withholding information. Culpable negligence is negligent conduct. Fraud is the intention and reliance on that deception to get someone to part with something of value or legal right. Material fact is relevant information. Misrepresentation is an untrue statement or fact. And moral turpitude is conduct contrary to honesty and good morals. Crimes include embezzlement, larceny, and robbery. Okay. And what we need to do is be able to explain the procedures involved in the reporting of violations the element of a valid complaint, and the investigation of complaints. So the first thing that happens is a complaint is filed with the DBPR, the Division of Real Estate. Okay, so the complaint is an alleged violation of law or rule. The uniform complaint form, the complaint process is consumer driven, in writing to be legally sufficient. It's legally sufficient if there's a violation of Florida statute 455 and 75, DBPR rule, or FREC rule. Okay, the complaint is investigated. The DRE has the authority to initiate an investigation. Okay, there's an inspection or audit of a brokerage office if needed. The complainant is the person who files the complaint. Okay, the copy of the complaint is sent to the subject of the investigation. The subject may submit a written response. The DRE conducts an investigation. So the DRE will issue an investigative report. They submit a report to the DBPR General Counsel to determine the type of violation that may have occurred. The complaint and informant are obtained during the investigation, are confidential until 10 days after probable cause is found. Okay, so no one knows this is going on until probable cause is found. If probable cause isn't found, it's never public. Okay. So number three, you have a determination will be made. So the determination is made as to probable cause. So if they find probable cause, which that means reasonable grounds for prosecution, okay, they'll conduct a probable cause panel. So each probable cause panel is composed of 2 individuals. One panel member must be a currently serving on the commission, and at least one member must be a former or current professional commission member. Okay, but one has to be current for sure. There's a grand jury arrangement. Okay, so that means the determination is made by majority vote as to whether probable cause exists. Okay, the complainant and subject of the complaint are sent written notifications of the outcome. And at this time, the case may be dismissed, okay, or dismissed with a letter of guidance if there's no probable cause. Okay. Does that make sense? Pretty clear?
Yeah, it's pretty clear.
Now let's look at number 4. Okay, let's say probable cause is found. Okay, a formal complaint is then issued when that probable cause is found. Okay, the administrative complaints are sent by email, regular mail, U.S. mail, or certified mail to the address of record. Okay, the probable cause exists. The DBPR files a formal complaint. The allegations of facts and charges against the licensee. The copy is sent to the associate's broker. The election of rights form is sent with the formal complaint. Remember the election of right form? If you get that, you have 21 days to respond. You don't respond, you're admitting to guilt, right?
Okay.
Good. So number 5, an informal or a formal hearing is conducted. An informal hearing is conducted if there's no disputed facts. The case is heard by FREC at the commission meeting. The licensee admits to the facts of the case. The licensee can submit mitigation in hopes of reducing the penalty. The FREC probable cause panel will be excused, and then they decide the case and impose the penalty at that point. The final order is issued at that point. FREC issues the final order, the final decision as to innocent or guilt, and the penalty. The probable cause members will then be excused. FREC considers the law judge's report and recommended order and filed exceptions, and copies are mailed to all parties. Okay, the final order may be appealed. So a licensee may appeal the order 30, and so if they get the order, they can appeal it up to 30 days. That appeal is filed with the DBPR and the District Court of Appeals. The licensee may request a stay of enforcement. That means if they're getting their license revoked or suspended, this will stop the suspension or revocation pending the appeal. So while the appeal's going on, you'll still, it won't affect you because you're innocent until proven guilty, right? So even all this was done, you're appealing it. So until that appeal's worked out, you still have the right to appeal, right?
And to do real estate business.
Yep. And then if that is done, it's a writ of supersedis. And that will supersede the FREC order until the appeal is heard. So you can get appealed, you can get it turned around, or you can get an appeal and lose, but then you'll lose your license then, right? Or you'll get it reinstated, or it'll be reinstated and you'll never lose it actually, if it's overturned by the appeal. Okay. All right. So let's describe the composition of the probable cause panel, which we talked about that. Okay. Each probable cause panel is comprised of two people, like we said. One member must serve on a commission. One member must be current or former commission member. Okay, let's describe the hearing process. If the subject of the complaint fails to timely respond to the election of rights, 21 days, right? The licensee respondent has waived the election of rights and by default admits to the charges. The case proceeds and is heard by FREC in an informal hearing. The licensee may request a formal hearing. The formal hearing required if there are disputed facts. If you don't agree and plead guilty, you'll have a formal hearing. Okay, the DBPR must agree that there are disputed facts. Florida Statute 120, it's in the Division of Administrative Hearings, and there's an administrative law judge who oversees it. Okay, the administrative law judge will give a recommended order. Okay, that recommended order gets submitted to FREC. Okay, there's a findings of fact, a conclusion of law, and a recommended penalty in accordance with FREC's range of penalties. That's the order. The judge says it's guilty or not guilty. Here's the conclusion. Here's why, and here's what I recommend. Right. At that point, FREC recognized the events that would cause a license application to be. I'm sorry. At that point, the recommended order goes to FREC, and then they make their decision. Right. They don't have to abide by that, but they usually do. Okay, so the next thing you have to do is recognize events that would cause a license application to be denied. Okay. Now remember, administrative, FREC is only allowed administrative penalties, right? They can't do anything. It's all administrative. So I want to go over, remember we had this little spreadsheet in our course that we created. So you got to remember, these are the penalties, right? Remember you asked me about the notice of noncompliance. Remember in the practice exam, we were talking about that?
Yes.
So the most minor is notice of noncompliance by the Division of Real Estate. The citation is minor by Division of Real Estate. Reprimand, minor by FREC. Denial of application or license, minor by FREC. Probation, you're getting more serious, right? By FREC. Fine by FREC. Suspension by FREC. It's pretty severe. Revocation is done by FREC. Okay. Now you need to distinguish among the various penalties that may be issued by a court of law, right? Because that administrative is administrative, right? That's not criminal. The court of law is money and criminal, right?
Yeah.
So you have civil penalties are imposed by civil courts. For example, a buyer sues in civil court for monetary damages resulting from unpaid rent to brokers culpable of negligence. Let's say the broker was a property manager. You know, maybe they didn't collect the rent and give it to the owner, right? So this could allow a buyer to file a complaint against a broker's license with the DRE for possible discipline. Not only can they sue them in court, they can also file a complaint about discipline. And then criminal penalties are issued in criminal courts. Okay. So in an investigation, if the DBPR finds any criminal violations or any activity, they must report that to the state attorney's office, and then they'll proceed if they want to prosecute. Right. So let's look at the criminal penalties. Right. A second-degree misdemeanor is punishable by up to $500 fine and up to 60 days in jail. First-degree misdemeanor is up to $1,000 fine and 1 year in jail, up to 1 year in jail. And a third-degree felony is up to $5,000 fine, up to 5 years in jail. So that's the penalties you need to know for your examination. Okay. Explain the provisions of a real estate recovery fund. We need to understand that. So the recovery fund reimburses consumers who have been financially injured by a licensee. It's the last resort, though. You got to sue them. You got to try to get the judgment served, and if they have no assets, then you use this. It involves a civil suit in a Florida court for monetary losses suffered in Florida real estate transactions. The losses are caused the losses are caused by actions of a real estate licensee. The fund will never reimburse punitive, treble, or interest on judgments, just actual damages. A broker who complies with an EDO may be reimbursed the amount of the EDO, the broker's attorney's fees, and costs. Remember, if they're found not guilty, remember if they follow the EDO, and then the people sue them, and if they lose, they'll reimburse, and you don't have to pay that back, right? If the plaintiff prevails in court, the fund will reimburse the plaintiff's attorney's fees and court costs as well. That's clear? You're good on that?
Clear on that.
Okay. All right, and that is the end of Unit 6 review. Okay. Now we're going to come into Unit 7. Okay, federal and state laws pertaining to real estate. Okay. There's going to be 4% of the exam on this section. Okay. So that means 4 questions that you're going to see. Okay. Do you have any questions on this unit before we start?
On this one?
Yep.
Nope.
All right. There we go. Okay. So the first thing we have to understand is we need to be able to describe the features of the Civil Rights Act, 1866, 1964, and 1968, and explain the significance of the Jones Mayer court case. So Civil Rights Act of 1866, it prohibits discrimination based on race in all real estate transactions, sale or rental in residential and commercial, no exceptions. And the Jones versus Mayer Supreme Court case was the ignition for this. Okay. The Civil Rights Act of 1964, it ended racial segregation in schools, workplaces, and public accommodations. It prohibits discrimination based on race, color, religion, and national origin. Public accommodations are like hotels, restaurants, gas stations, places of entertainment. And the public facilities are also government-run facilities, public pools, things like that, like public places, libraries, things like that. Then the Civil Rights Act of 1968 is the Fair Housing Act with the amendments. That's the changes. This is where Title VIII of Civil Rights Act was created in the Act of 1968. It makes discrimination illegal in sales, leasing, advertising, sales or rentals, financing, and brokerage services if based on race, color, religion, sex, national origin. Okay. And in 1988, they amended it. It included disabilities, mental or physical. And that includes any physical or mental impairment that limits major life activities. Okay. Let's look at familial status. Also, it adds, in addition to the mental disabilities, it added familial status. And that's families with children under 18 and pregnant women. They cannot be discriminated against. Okay. And in 2021, there was another addition of sexual orientation and gender identity. Okay. The president signed an executive order requiring HUD to enforce Fair Housing Act prohibiting discrimination based on sexual orientation and gender identity. HUD extended protections based on sex discrimination to include sexual orientation and gender identity at that time in 21. Okay, the next thing you have to do is list the property that's exempt from 1968 Fair Housing Act and describe the types of discriminatory acts that are prohibited under the Fair Housing Act. Okay, so the provision of the Fair Housing Act, any residential transactions are covered. Okay, government owned, privately owned if broker is employed to sell or rent the property, single family homes owned by a business entity, single or rental owned by persons who owns 4 or more units, multifamily housing of 5 or more units, multifamily housing of 4 or fewer units if the owner does not reside in one unit. Now there is an exemption. If you have a 4 or fewer unit and the owner lives in one, that is exempt for some reason. Okay. The exemption from the familial status protection. You know, you have housing for Older Persons Act, 55 and older communities, 62 and older communities. So all units must be occupied by 62 or older, or at least 80 of the units are occupied by 55 or older. Those housings, they're exempt, right? Because you got to have a minimum age to live there. So they're exempt from the familial status. Also, housing operated by religious organizations and private clubs that are not operated for commercial purposes. They can have certain nationalities, certain things. They're exempt from the law. Okay. Now, the prohibited activities. We talked a little bit about this when we did the review, the practice test. Steering. Steering is channeling home seekers to or away from neighborhoods for any reason. Blockbusting is use entry or rumor of entry of a protected class to urge owners to sell. Redlining is denying loans or insurance coverage or different terms and prices for the same coverage and conditions for homes in certain neighborhoods. So you can't charge different rates for things like that. Go ahead.
Could you please explain this one a little more, please?
Which one?
The one that I put the arrow on, the housing.
Yeah.
No, thank you.
Okay. Yeah. So let's say a church buys housing for their elderly.
Mm-hmm.
And they want the housing for the elderly for their church members only. So they can rent them to church members only. They don't have to follow these laws. They can rent as long as the church isn't discriminating, right?
Got it. Okay.
And then a private club is like a, social club, private like membership club, right? It's not commercial. They're usually ethnic clubs. You have different ethnic clubs. They buy property. They want to rent to their members. They're allowed to rent to their members and not outside of their community.
Gotcha.
That's exempt. Okay.
All right.
That makes sense?
Yeah.
You good on the redlining, blockbusting, and steering?
Oh yeah, definitely.
All right, so let's look at, you have to describe the objectives and major provisions with the Americans with Disabilities Act. It protects employment and accessibility rights of individuals with mental and physical disabilities. People with disabilities cannot be denied access to public transportation, public accommodations, and commercial facilities. It includes real estate brokerages, offices, even if located in private residences. Modifications may be required if readily achievable. Okay, the Florida Americans with Disability Implementation Act is the state law, right? There's a federal law as well. Okay. Any questions?
No.
That, remember I used the example, remember the back of our building has the ramp and I have the handicap bathroom in the classroom behind me here?
Mm-hmm.
When I looked for offices, I made sure that was already done because I didn't want to have to put the expenses of putting bathrooms and that can add up to like 20 grand real quick, bathrooms and ramps and things. So I made sure I found a building that was already in accordance with that. And the building I have here was an insurance company for like 7 or 10 years prior. So it was already retrofitted. It was already done to match all the federal and state laws. So.
Cool.
Okay, so next you have to describe describe the major provisions of the Interstate Land Sale Full Disclosure Act. Okay, this is a federal law that regulates sale or lease of land. It's administered by the CFPB, the Consumer Financial Protection Bureau. Certain developers must register developments and disclose to prospects facts regarding the real estate. And there's two components. Okay, there's a registration requirement and a property report. The registration requirement is if developers register a subdivision of 100 or more lots with the Consumer Financial Protection Bureau. So if it's 100 more lots, they must register it. If the developers are of 24 or more lots, they must provide purchaser with the property report disclosure before signing the contract. And they may cancel within 7 days after review. Buyers who do not receive the report prior to signing contract may cancel within 2 years and get their money back, like cancel the contract. They have a right to. Okay. Now let's look at the provisions of the Florida Real Estate Landlord and Tenant Act. Okay. This is something you want to look at now, right? Because it's something we talked about prior, right?
Yes.
So this places the landlords and tenants on equitable legal basis. I just saw Aiden just saw on the news, there's a rental complex that stopped trash pickup and they didn't hire a new trash company. And the people are putting their trash outside and there's no dumpsters, no nothing. And they're suing them because they have to provide trash. And they're suing the people, right? It's going on right now. I just saw it last night. So it applies to a rental of dwelling units, okay? Not transient facilities, not Airbnb, not hotels, not mobile home lots, not commercial leases. Landlords must account for deposits and advance rents. They must hold the money in a separate non-interest-bearing Florida bank account. They must hold the money in a separate interest-bearing Florida account and pay the tenant at least 75% of the annual interest or 5% simple interest. Or they must post a bond for the amount of the security deposits in advance rents or $50,000, whichever is less, and pay the tenants 5 years, 5% per year in simple interest. Okay. Remember, this was on the practice exam. Landlords of 5 or more units must provide legal notice to tenants when within 30 days of collecting a deposit. The name, address of depository where the advance rent and security deposits are held, and they must indicate whether the tenant is entitled to interest on the deposit or not. Okay. Let's talk about broker management, property management. If the broker holds the funds on behalf of the landlord, the broker must abide by Chapter 475 regarding escrow funds. Deposits and advance rents are trust funds that must be deposited into the broker's escrow. Separate escrow account for property management is not required. You don't have to have separate accounts. You can have one account and everything can be in it. It'd be a nightmare, but it'll all be in it. Remember, $5,000 broker's funds are allowed to be maintained in that account. How much is it in the sales one? Do you remember?
1,000.
1,000. Good. Associates must deliver the rent and deposits to the broker by end of next business day. That's the same as a purchase, right? End of next business day. Yeah. Okay, renting to active military service. They must approve or deny rental applications within 7 days. If the service member has completed an application, a landlord must rent to the member. If they don't, they have to have a reason for denial. Okay. Let's talk about the sale of tenant-occupied homes. Unless specifically stated in the lease agreement, the sales of rented property does not terminate the lease. If a lease continues after the sale, security deposits and advance rents must be transferred to the new owner, and it requires a final accounting to the tenant at the time of transfer. Remember the prorations we did? Remember the rent prorations, goes at the day of closing? That's talking about that, right?
Yeah.
Okay, now obligations to maintain the premises. The landlord must meet health and building codes, insect and rodent extermination, garbage receptacles and pickup, working equipment for heat and running water. If those things aren't being provided for, they're in violation. A tenant must comply with the health and building codes, use reasonable care of operation and cleanliness of equipment, and not disturb the peace of others. Landlord's access to the premises. A tenant must allow a landlord to enter the property to make inspections, provide service, make repairs, and show property. Landlord may enter the property at any time in case of emergency. Otherwise, they're obligated to give reasonable notice. Reasonable notice to law is 12 hours. Okay. Vacating the premises. When a landlord is holding a security deposit, they must return it to the tenant within 15 days if no claim is to be made. They have to send written notice by certified mail within 30 days if a claim is made on the security deposit. At that point, the tenant has 15 days to respond to the landlord's written claim. If they dispute it and have an issue that they don't agree with, they have to handle it in civil court. They have to file a case. There's no conflicting demand rules, nothing like that, like on a sale. Okay. And let's look at how rental agreements can be terminated. Okay, now this is something that you want to look at for what we were talking about. If a landlord fails to maintain rented premises or fails to comply with rental agreement, the tenant may terminate the agreement. They have to give 7-day written notice of intent to cancel. The landlord has 7 days to correct the noncompliance. If the tenant desires to remain on the premises, rent may be reduced by the court. If uninhabitable, tenant may be relieved of the rent payments until it's fixed. Termination of rental agreement by the landlord, because the landlord could terminate it too. If a tenant fails to pay rent, there's a 3-step procedure. They give the tenant written notice demanding either rent payment or possession within 3 days. The tenant has 3 business days to pay the rent or surrender the premises. If they fail to do so, the landlord must initiate formal eviction in the county court. If the tenant vacates, the landlord must give tenant written notice of any claim on security deposit or advanced rent held by the landlord. Okay, eviction requirements. You must notify the tenant with in writing 3 days. If the tenant does not comply, file a complaint of eviction with the county. The tenant has 5 business days to respond to the complaint to the court. If the tenant continues to occupy without responding, final judgment is obtained from the court, and the court issues a writ of possession. The sheriff notifies the tenant of eviction, and an eviction will take place in 24 hours after it's posted. Okay? And that is the end of Unit 7. Do you have any questions on that?
No questions.
Okay. Okay, we're going to move on to Unit 8. Now, Unit 8, you're going to have 8% of the questions, which will be 8 questions on the exam. Just going to talk about property rights, estates, tenancies, condominiums, co-ops, community development districts, homeowners associations, and time sharing. Okay, so what we need to do is we need to be able to define real property based on the definition of Chapter 475 Florida statute. And it explains the physical components of real estate, of real property. Okay, so real property or real estate means any interest or estate in land and interest in business enterprises or business opportunities. It includes mineral rights. It does not include cemetery lots, renting of mobile home lots, or recreational vehicle lots in a home, a mobile home, or a park or a travel park. Okay, the physical components of land. You have surface rights, and that includes land and water rights, right? Remember the water rights, you have littoral rights, and that's associated with land abutting against non-flowing water bodies. That's like an ocean or a pond or a lake, right? Or Gulf, like up against the Gulf of Mexico on the West Coast. Okay, so think littoral, think lakes, right? Riparian rights are associated with land abutting a flowing waterway, like banks of the river or stream. Think riparian, you think river, right? Moving. The definitions associated with water rights. Okay, so you got to remember these. So you have accretion. Okay, that's the process of land buildup from waterborne rock, sand, and soil. Alluvion happens when accretion occurs. Alluvion is the new deposits resulting from the accretion. Erosion is the loss of land due to natural forces. And reliction is the receding of water, uncovering additional land. Okay, subsurface rights are also referred to as mineral rights. That's like oil, gold, silver, right in the ground. Air rights involve the space above. So you have to also be able to distinguish between real and personal property and explain the 4 tests that courts use to determine if an item is a fixture. Okay, so you have 2 basic types of property. You have real property, which is realty, and you have personal property. Okay, so personal property is going to be fixtures and your clothing and you know, a ceiling fan, when you buy it, it's personal property. When you install it, it's real property, right? Because it's attached. A washer and dryer, when you buy it, is personal property. When you connect it, it's physical property, right? It's real property. Okay. Same thing as stove, right? Same thing. Okay, so personality indicates personal property. Okay, so real property becomes personal property by act of severance. Okay, so if you put a ceiling fan in, it becomes real property. You take a ceiling fan out, now it's personal property. You put a washer and dryer in, it's real property. You take it out, it's physical, personal property, right? Okay, so personal property becomes real property by attachment, and it becomes real property becomes personal property by severance, taking it out, right? Fixture, okay, was originally personal property. Now it's permanently attached to be made part of the real property. Ceiling fan, washer, same concept, right? So you have 4 tests. What determines this? IRMA is the acronym we use. Okay, the intent of the parties. So if a washer and dryer is connected to the house is shown, the washer and dryer are there. Nothing is said that the washer and dryer are not included. They're going to assume that that's included, right? However, if you put in the listing agreement and on the sales and on the listing in the broker's comments, washer and dryer not included. Now that's the intent of the parties, right? Now the seller says we don't want to include it. The buyer says, well, I'll buy it, but I want it. Then they can negotiate it. The seller can still say no. But if you don't say anything and the seller takes that, they stole from the house. They took property. They're going to be sued, right? They can be sued. Okay, so intent of the parties. Relationship or agreement of the parties. They decide what they're going to do, right? They agree on it. It's in the contract. Method or degree of attachment. Is it something that can be easily removed or no? Like if you have a fence is part of when you buy the materials for a fence, it's personal property. When you install the fence, it's real property. Now, is it feasible to take a fence out and take it with you when you move? I mean, that's the method of attachment, right? The degree of it, right? So it doesn't make sense, right? You're not going to take a fence. Okay, and then adaption of the item. Okay, is it easily adaptable? Okay. So let's look at the little chart we made. So there's fixtures and there's trade fixtures. Trade fixtures are in commercial property. Fixtures are on real property. Okay. And if you have to determine these, a fixture is in real property. Okay. It's the nature of property is permanent. Okay. And the use of the property is for residential sales and purchases. And the sales contract, it would be included in the sale. You would include that, right? Trade fixtures are personal property. It's removable. The use of it is normally in a commercial lease. Like you have a restaurant, all the equipment inside. Okay, that's the owners, right? And it's usually not included in the sale unless you include it in the sale, right? So, if an owner of a property is selling a building and there's a restaurant in it and the restaurant is leasing that restaurant, it's not the owner. That equipment in there is not the building. They're not buying that. They're buying the building, right? That depending on the lease, depending on the deal, that equipment is the restaurant owners, right? You're not taking their ovens and stoves and things like that, pots, pans, dishes, like that, right? Does that make sense?
Yes.
Okay. Now let's talk a little bit about describing the bundle of legal rights associated with real property ownership. Okay. A second here. There we go. So let's talk about the legal bundle of rights. All right. You have Deep C is the acronym that we use. Okay. You have disposition, which is the right of dispose. These are the bundle of rights, whatever you want to do with your property. You have enjoyment. That's the right to use it, quiet enjoyment. Exclusion, right to prevent trespass. Possession, right to occupy it anytime you want. And control, right to unlawful interrupted use. Okay. You have on that. 1 second here. Okay, good. All right. Now let's list the principles. List the principal type of estates. You have tenancies are also estates. Now you can describe their characteristics and describe the benefits and protections associated with the Florida homestead law. Okay. So there's two general groups of estates and tenancies. Okay. You have one, a freehold estate, and that's for indefinite length, unknown duration, right? You own it. You bought it. You do what you want with it. Sell it whenever you like. Okay. Ownership interest for an indefinite period, which is the unknown duration, right? You can sell it whenever you want. There's 2 types of freehold estates. You have fee simple. Okay. This one has the largest bundle of rights and it can be inherited and passed on. Okay. It's the most comprehensive ownership. There's absolute and complete ownership. As I said, it can be inherited from somebody and it can be passed on to your heirs. Okay. It's also known as fee or fee simple absolute. and you have the power to use it, dispose it, and descend it to your heirs. Life estate is measured by a person's lifespan. Okay, this is created by a person who holds a fee simple title to the real property. The freehold estate is limited in duration to the owner's lifespan and or designated lifespans of the persons. Okay. Conventional life estates are created by an agreement of the parties, and the grantor transfers life estate to another. The life estate creates two distinct ownership interests from the original fee simple estate. Okay. The possible persons who hold title once the life estate ends there's two possibilities. It can be an estate in reversion, means it reverts back to the original grantor. And it can also be a remainder estate. That means the property goes to a remainder man. So in the deed, it's going to say who gets the property afterwards. It goes to somebody or something, or it goes back to the person who, or the trust or whoever gave it. Okay. Life estates can also be created by law. So for example, if a homestead is titled in one spouse's name only, by operation of law, the surviving spouse receives a legal life estate to the homestead property. For this reason, signatures of both spouses are required on all contracts, mortgages, and deeds on homesteaded property, if it's in one person's or both name. Names have to be on both, right? And signed. Okay, a homestead is the right, you have the right to homestead the owner's permanent principal residence. And there's protections and benefits when you're homesteaded. Okay, the protection of the family, the legal life estate. Okay, protection of the homestead from forced sale. If you get sued, not from foreclosure. If you don't pay your mortgage, they're going to take your house, right? But it's not from getting sued. Okay, tax exemption is up to 50,000, right? Plus you have those additional exemptions for different cases. The size restriction of protected homesteads is 160 acres outside the city or half an acre within the city. And that's determined by the zoning and the planning where it is. Okay, and there's also personal property protection of $1,000 in value. Okay, that's the freehold. Now you have the second one, which is leasehold, right? So leasehold is also known as non-freehold. And what it means is there's a fixed known duration. You have a 1-year lease, a 5-year lease, a 10-year lease, right? It's measured in calendar time, and you have that known duration. It's non-freehold because it does not exist for an infinite period of time. Okay. The non-freehold or less than freehold is called, it's not an ownership interest. Basically what they're doing is transferring the right of enjoyment, which is the use and possession, for a period of time. The owner still owns it. The tenant becomes the leasehold for the period of time, right? So you have 3 types of non-freehold leasehold estates, right? Number 1 is an estate for years. It's also known as tenancy for years. There's a specific starting and ending date, which is called a designated period. There's no notice to terminate because it's already, you know when the ending date is. They don't have to give you notice. You know it's ending on a certain date. It's created by a written lease agreement, and it establishes the tenant's interest in the property, but it does not convey legal title, right? You're not selling the property. You're giving the interest. You're giving the quiet enjoyment and the use, right? Tenancy at will, either an oral agreement or an agreement with a beginning date, but no fixed termination date. Okay, it's a tenancy without specific term, and the notice to terminate is set in statute. So if you're renting a place week to week, you got to give 7 days notice. If you're renting a place month to month, you got to give 15 days notice. Okay, that's like a month to month, a tenancy at will. You're moving in this day, we don't know when you're moving out. Then you have something called a tenancy at sufferance. Okay, this is when you have a tenancy for years and the tenant stays in possession of the property beyond the ending date without the landlord's consent or written agreement. Basically like a tenant holdover. Okay, you know, some people say, hey, look, I'm giving you a year lease, and then when it expires, you go month to month, right? That would technically be a tenancy in sufferance. Okay, a tenant stays in possession of the property beyond the ending date without the consent. It's a tenant holdover. Now, if with written consent, the landlord, then it becomes a tenancy at will, right? So if the landlord says, okay, I'll put it on paper, you can now rent month to month, just give me 15 days notice when you leave, right? It would go to tenancy at will. But if they never give you a new lease and you just live off that old lease, it's going to be a tenancy at sufferance. Okay. Now let's look at the difference between sole and concurrent ownership. So sole ownership is when one person owns a property, and then concurrent is when there's two or more, right? So when one person owns a property, it's called estate and severalty. Title is held in one person's name, and that's sole ownership. Okay. Separate property titled to one spouse, either before marriage or by inheritance, okay, would be this type of property. Like if you have a marital asset acquired during marriage, it can still be one person, but then the other person, if you're homesteaded, has interest in it, right? Now let's look at concurrent ownership. Okay, two or more persons own property at the same time. There's three types of concurrent ownership. Okay, you have tenancy in common. Concurrent ownership of two or more people. They acquire the title at the same or different times, so people can be added and taken off of it as time goes on. Okay. Undivided interest in the entire property. So one person has undivided interest, they can come and go as they please, and so does everybody else. No one can tell somebody they can't come to the property. Okay, equal or unequal shares. It could be equally divided, or one can own more than the other. Okay, so it's called proportionate share. And heirs inherit it. There's no right of survivorship. So if one dies, it doesn't go to the other people. It goes to whoever they name in their will, and they can also sell it to somebody else. They don't need the other people's permission to sell their share. Okay. Then you have tenancy by the entireties. Concurrent ownership created by a married couple only. You have to be married to get this. You must be married at the time when you take title. You can't buy the house 2 weeks before you get married. You got to be physically married to get title this way. Okay, so tenancy of the entireties is implied if a couple is married. So if somebody's married and they're getting a house, this is going to be the deed. This is going to be the ownership type that they get automatically, unless you tell them they want it differently, right? It applies to all types of real estate purchased by married couples. It could be residential, could be commercial, could be land, could be everything. Okay, actions affecting property require consent of both spouses. So, if it wants to, both people have to sign all the documents, right? Agreements, contracts, closing, deed. When one spouse dies, ownership interest transfers to the surviving spouse by right of survivorship. In event of divorce, tenancies by entireties becomes tenancy in common. Okay, automatically reverse the tenancy in common. Joint tenancy has the right of survivorship. The death of a co-owner, the co-owner title interest conveys to the surviving co-owners. 4 people, 1 passes, it goes to 3. 3 goes to 2. 2 goes to 1, right? When a spouse dies, the ownership transfers to the surviving spouses by right of survivorship. In event of divorce, tenancy by entireties. I'm sorry, I went off the wrong thing. 1 second, I went back to the wrong one. So right of survivorship, the death of the co-owner, title interest conveys to the surviving co-owners. Title does not convey to the heirs. Okay. Specific wording in the deed must provide for survivorship. So after the last person dies, it has to be in the deed where it's going, predetermined. Okay. There's 4 unities to joint tenancy. Okay. You have possession. It's undivided interest, right? People can come and go whenever they want. You can't tell somebody they have to leave. Interest is equal ownership. There's no person that owns more than the other. It's always equal. The title is acquired on the same deed. So when you buy it, they're the people on it. You can't add people on and off. Time. Acquire interest at the same time. Now, you could always refinance it, do deed transfers, things like that. But you can't, it would have to change the status, right? It has to be acquired at the same time as the purchase. Okay? Any questions on that?
No.
All right, so now let's distinguish among cooperatives, condominiums, and timeshares and describe the main documents associated with the miniums. Okay. So remember, cooperatives, Florida statute 719 is dedicated to them. They're multifamily buildings owned by a corporation. Unit owners purchase shares of stock for each unit. Stock ownership entitles the purchaser to a proprietary lease and right to occupy. Property taxes are assessed on each unit. The owners can deduct the real estate taxes and purchase interest. Shareholders will pay a prorated share of property taxes, and the corporation pays the tax bill. The cooperative disclosure and cancellations. Okay, so when you go into contract with the developer, there's a disclosure. The buyer has the right to cancel within 15 days of signing the contract and receipt of the cooperative documents. Right? So if you sign the contract but don't get the documents for 10 more days, that clock doesn't start till you get the documents, right? So new construction from a developer, 15 days. In a resale contract, you got to get the documents and you have 3 days, right, before signing. Or the buyer has the right to cancel 3 days of signing the contract and the receipt of the documents. So whenever you get both of those, your 3-day period starts. So, right, 15 days developer, 3 days resale. Condominiums, Florida statute 718. Okay. It consists of condo units and common elements. Okay. You own a condo unit in fee simple plus an undivided fractional shares of the common elements. The deed conveys ownership. Common elements legally attached to each unit and transfer with the unit. That's like the pool, the gym, all the equipment, like anything that's coming with the unit. When you sell the unit, it goes with it. Property taxes are levied on individual units. Okay, condominium documents that must be given to buyer of a new residential condo unit sold by developer and resale purchases. Okay, the declaration of condominium, that's the document that is creating the condo by recording that declaration, right? Constructive notice. They have an articles of incorporation for the association. They have bylaws, which are operational requirements, rules, and regulations. They have a frequently asked question sheet. This is information regarding leasing the units, assessments, all the normal questions. Purchaser has 3 calendar days to cancel the contract after signing the contract, and the clock does not begin until the buyer receives all the required the condo docs. Okay, so remember, resale 3 days, developer 15 days, right? Condos and co-ops. Now, condo units sold by the developer. In addition to the 4 documents we just talked about, they also, if it's 20 or more units, more than 20 units, they have to give a prospectus. If it's estimated operating budget, they got to give that too, because they don't know what the budget is until they start operating. But they have to give you an estimated budget. And the purchaser has 15 calendar days to cancel after signing the contract, and the clock doesn't begin until after they receive all the condo docs and sign off on that. Okay, so remember, 3 days resale, 15 days developer. Okay, so resale condo units by the owners also have a few different disclosures. They get the 4 primary ones, and they got the 3 business days to cancel after they get the rest of them. Okay, now timeshares, they have their own Florida statute 721. Okay, units are divided into time segments of ownership, usually 52 weeks. The deeds or other ownership evidences are prepared for each ownership segment. So you'll have 20 or 52 deeds, right? Real estate license is required to sell another's timeshare for compensation. The exemptions are, if it's a salaried employee of the timeshare developer, selling timeshares for the developer, provided they're not paid commission and not paid on a transactional basis. Owners of timeshares can sell their own timeshares without representation. Timeshare resale listing agreements. It's illegal to collect advance fees for listing a timeshare. Your required disclosure, not guaranteeing a sale. Other requirements are what the commissions are, the terms, the broker services, termination and listing extension rights, and if there's any judgments or litigation against the broker. Sale contract disclosures for timeshares. A timeshare sales contract must contain the current year's timeshare assessment. If the property taxes are not included in the assessment, the most recent property tax assessment is also required. There has to be a form of timeshare ownership. Is it fee simple? How are they owning it? Who the managing entity is, terms for closing and terms for the closing and the cost of it, and if there's an existence of a mandatory exchange program. Okay, right of cancellation. A timeshare is different than the others. The buyer has the right to cancel within 10 days of signing a timeshare sale contract or receipt of public offering statement, whichever occurs later. That 10-day period is for new timeshares from a developer and also resale timeshares. Okay, so on this one, it's 10 days either way. Timeshare ownership interval, timeshare ownership, okay? There's two different types of ownership. You have interval ownership, which is fee simple ownership. The fractional interest is divided by deed. That means you buy it and you own it forever, and you decide when you're going to sell it. Right to use timeshare ownership is usage of timeshare, but it's limited to a number of years. And the ownership of timeshare remains with the developer. So that kind say you buy it, you have access to it for 50 years. After 50 years, it goes back to the developer. Okay. That's the right to use. Okay. And remember the days, 3 business days for resales of co-ops and condos, 10 calendar days for timeshares for developer and resale, 15 days for residential co-op and condo units by the developer. Okay. Do you have any questions on that?
No questions.
All right. So what we're going to do is let's end part 1 and we'll continue part 2 on our next session where we begin with unit 9 and go to the end of the review. Okay. Do you have any questions on that?
I do not have any questions, though.
That's good. Okay, good. So we'll end this and we'll get this completed.